Hello, everyone. Welcome to the Texas Property Code 101 webinar. My name is Cliff Davis. I'm a shareholder here at Roberts Markel Weinberg Butler Haley. Today we're going to talk about some property code basics. We're going to jump around on a number of different topics just to kind of give an overview of some of the things in the property code. And as we'll discuss at the end, there's going to be a property code 201. I believe that's in the next few weeks or next month. So we'll go ahead and get started here. And we'll talk about the discussion points for today. And those will be some property code basics, talk a little bit about open records, open meetings, amending restrictions and declarations, and hearings before the board. And so first we're going to talk about the difference between a condominium and a non-condominium. And by the way, too, during this, if you have a question, you can type it into the chat function. And at the end of this, time allowing, we'll go through and answer as many questions as we can. So condominiums, there's two types of condominiums. There's pre-1994 condominiums, and they're called pre-TUCA condos, and there's post-1994, and those are TUCA condos. And TUCA is the Texas Uniform Condominium Act. So all condominiums that were established on or after January 1st of 1994 are governed by Chapter 82 of the Texas Property Code, which is a little more extensive than the law that existed before that, which is Chapter 81 of the Texas Property Code. So ownership of a condo, which when we think of a condo, we typically think of a high-rise building with a lot of what looks like apartments in it. And what you own when you own a condo is the airspace within the 4 exterior walls of your unit. And then every owner has an undivided interest in the common areas. Now, not all condos are high rises, and we'll talk about that a little bit more. Sometimes they don't look like what you would think is what you typically believe a condo would look like. And one way to tell is if your deed refers to a unit number, and if it does, that's probably a condominium. So in a condominium development, the association does not own any property, doesn't pay any property taxes. The common elements, like I said, are owned by an equal percentage, most likely by every owner of the condominium. And sometimes they can look like a single family home. It just depends on how they're organized. There's now office condominium developments. There's dockondominiums where you might own a dock at a marina. That's a condominium. There's these barnominiums. There's all kind of different ways now a condo can look. And townhomes can sometimes be confusing. And really what this is going to cut down to is that a townhome sometimes can be called the Laurel Lane Townhome Association, and it's actually a condominium association. A lot of times townhomes are non-condominiums or single-family homes, but sometimes they are condominiums. The biggest clue is who owns the dirt underneath. If you own a condominium, you do not own any dirt. If you own a non-condominium, you own the dirt that's underneath your residence. And so you can look at the deed and see if it refers to a lot or block number, which is probably a non-condominium, or if it's a unit number, it's a condominium. Does the deed speak to an undivided interest in common elements? If so, it is a condominium. So really, the document that can really tell you what that is would be the declaration or the deed restrictions. If it's a condominium, most likely within the first paragraph or the first few pages of that, it will say that it is developed as a condominium regime. So that's really the sure way to tell of what you're buying, is to look at the declaration, see if it refers to a condominium regime. And if so, no matter what it looks like, it's a condominium. Single family home. So these are non-condominium developments, and typically in those, the association owns the common areas. The owners have the right to enjoy the common areas because they're members of the association. That right is typically in the declaration where it speaks to the owners having the right to use common areas, or maybe gives the owners an easement to the common areas. There's a plat map that's filed. that shows individual lots and common areas. And if you've never seen a plat map, it's something that gets filed really before the first lot is sold, and it shows you where the streets are, and then defines each lot. And it defines those lots by putting a number on the lot and a block number. So that's why if you look on a deed and it says lot 1, block 2, if you go and look on your plat map, you will find lot 1 in block 2, and that identifies your property. And again, it's lot and block, and doesn't mention, if the deed describes it as lot and block and doesn't mention an ownership interest, you're looking at a non-condominium development. Be aware, though, that sometimes what appears to be a single family home can be part of a condominium. And again, it goes back to looking at that declaration to determine how the developer organized the neighborhood, if it's a condominium or if it's a non-condominium or single family or possibly a non-condominium townhome development. So let's talk a little bit about open records. And we're going to talk about open records in the non-condominium world. So these are single family home developments. And one of the principal laws that governs non-condominium developments is Chapter 209 of the Texas Property Code. So Chapter 209 of the Texas Property Code provides that every association has to adopt a policy for records production. Hopefully all of you out there that are manage one of these has already adopted that and filed it with the county. That open records production is how an owner, if they want to see association records, the records production statute and the policy that every association must file lays out the procedure on how an association or on how an owner can request to see copies of those open records. There are some limitations. We'll talk about those a little bit. There's a time requirement. So when you get an open records request, if you're a manager and you receive one, a clock starts ticking. And the first part of that clock is a 10 business day period in which you have to respond to that open records request. The law does allow the association to charge for some of the costs of providing those records. And those limitations are in the Texas Administrative Code. They're fairly nominal is the amounts that can be charged for copies and for the labor to put together the records request that you receive from an owner. So like I said, there are some limitations. Attorney records are typically not an association record. So if you get a request from an owner that says they want to see, all the attorney file or the attorney communications about their neighbors, what they believe is their neighbor's deed restriction violation, that's something you don't have to provide. It's important to remember that there's another statute in Chapter 209 that talks about records retention, and that lays out how long you have to keep association records. For the longest time period, I believe it's 7 years for most things. So it's important that you look at that statute, that you also have a records retention policy as recommended, and that will tell you how long you have to keep certain records. One thing to keep in mind, though, is, sometimes I hear from a manager or a board member, and they'll say, we've got 30 years worth of records stored in our warehouse or stored in, the management company office or at somebody's house. And really, it's not a good idea to keep those like that. If you get into a lawsuit over some issue and the other side sends you a discovery request and says, we want to see the last 30 years of records you have on a certain issue, if you have them, you have to produce them. Our recommendation is that you keep, maybe with a few exceptions, only the statutory minimum number of years of records, and you destroy older records, just to avoid the fishing expeditions that somebody might engage in. If they're in a lawsuit with you and they go back and find something from 20 years ago that you really didn't even need to keep. So that's something kind of to talk about if you're a board member, to talk about with your management company. And if you're a management company, to think about, how are we complying with the statutory minimums for keeping records, and what should we do with these records that are older than the time frame that the law requires us to keep those records. If you do not respond properly to an open records request, the law allows the owner to file a suit in a justice of the peace court. And if you don't get it right and don't provide them with what they need, that JP court can order the association to provide the records, and more importantly, can award attorney fees to the requesting owner who was denied access for whatever reason. So it's really important that as a manager, you understand that when you get an open records request, the clock starts ticking, and that you need to respond within 10 days, either by telling them these are the times you can come and view these records, or if they request copies, provide the copies within that 10-day time frame. And Kyle, let's go to the next one. But something to remember too is that the association can charge in advance the cost of producing those records. So if they ask for voluminous copies of records, you can determine what the cost is going to be to provide those, and then within that 10 days, send a letter to the owner saying, we've received your requests, the cost for us to produce those is X, and you have to pay that before we're going to send you the copies. So there is a way, if it's a lot of copies and it's going to take some time and there's a cost involved, that you don't have to just provide the copies within 10 days. You can require advance payment. If you're in that situation, you should contact your attorney to talk about it and to just kind of make sure that you don't trip up over the timelines in the statute. So condominiums now also have a requirement for an open records policy, and it more or less tracks the non-condominium. There's some limitations on what records you have to provide. Obviously, attorney fees, attorney records you don't have to provide. And for both condos and non-condos, if somebody says, I want to see all the deed restriction violation letters you sent to an owner, typically don't have to provide those. If they ask that I want to see the, tell me how much this person owes the association, you do not have to provide those types of records. Again, in condos, you can charge for the records, but it's the same Texas Administrative Code requirements that sets the maximum that you can charge to gather and provide those records. So really, it more or less tracks the non-condominium open records policy. And I see we're getting some questions, so keep asking your questions through chat if you have a question on anything. Kyle, let's go to the next one. Talk a little bit about open meetings. And again, you see the reference to Texas Property Code Chapter 209. So that means we're talking about non-condominium developments. Chapter 209 of the Property Code does not apply to condominiums, only to non-condominiums. Chapter 209 requires that association board meetings be open to all the members. A board meeting is anywhere where there's a quorum of the board present and they're considering association business and taking action on association business. You should keep meeting minutes of all board meetings. And we get a lot of questions on meeting minutes of what should be in there. And the general purpose of board meeting minutes is to memorialize decisions of the board. They're not to keep a record of everything that was said, of who said what and what somebody wanted. And we hear owners all the time, or a lot of times at board meetings, say, I want that in the meeting minutes. You're not required to put things in the meeting minutes upon demand. Really what you want is a record that protects the board to show that they made the decision, and in some cases we're required that decision was made in the open session of a properly noticed board meeting. So for example, you want the board meeting minutes to say a motion was made to hire ABC Landscaping, the motion was seconded, vote was held, and the motion passed, and so they're hired. So then down the road, when someone says, when did the board authorize hiring ABC Landscaping, you can pull those meeting minutes out and show it that it was adopted in the open session, approved in the open session of a properly noticed meeting. So really, you want to memorialize decisions in meeting minutes. There may be times where you want to have entries for historical reference, that something that was discussed that you think maybe we need to keep a record of this. So that's okay to put in meeting minutes for historical reference. But you don't need 10-page meeting minutes that recite everything that was said, that recite every question an owner asked during an open forum if you have one in the answer. You really just want the primary purpose of those is to memorialize decisions of the board. The law does allow the board to go into executive session, and the property code lays out the items that can be discussed in executive session: personnel matters, pending or threatened litigation, contract negotiations, enforcement actions, confidential attorney communications, individual owner issues. So those are all things that can be discussed in executive session. Typically what I tell associations is, on your agenda, you should have an agenda entry saying the board will convene and adjourn into executive session to discuss, and I list these things verbatim from the property code. And if it's not in one of those, if it's not covered, whatever the board wants to discuss under one of those areas, you should probably talk to your attorney about if that's something that should be discussed in executive session. I think it's important to remember that the intent of the law is that all association business be conducted out in the open session. Now, obviously, the law allows for executive sessions to discuss kind of more private matters. You're not going to talk about a deed restriction violation lawsuit or a collection lawsuit out in front of everybody. You should not do that. But a lot of boards sometimes want to not discuss things that they should discuss in the open session, and they want to do it in executive session. And again, you look at this list of items, which comes straight from the property code, and if it's not under one of those, it's probably something that should be discussed in the open session. The law wants the members to be able to see the board talking about association business in the open session. If a decision is made in the open session, when you come in the executive session, when you come out of executive session, you have to announce the decision, and if it involved an expense, announce what that expense was. Now, having said that, I can really never think of any decision that should be made in executive session. And I'm sure there are some exceptions out there, but really, you want to try to make all of your decisions in the open session so that the owners can see and hear that decision. The law does allow, I mentioned that really what the law wants is all the business to be conducted in the open session of a properly noticed meeting, but the law does realize that sometimes that's not possible. For example, if your pool pump breaks in the middle of the summer and your next board meeting is a month from then, you can't wait till then. So the law does allow boards to take action outside of a meeting through an email vote. There are, however, some limitations on the board's authority to act outside of a meeting. They're listed here on this slide, and I want to make special note of something that's on there. In the initiation of foreclosure actions, the initiation of enforcement actions, and it's not on here, but also levying a fine, are things that you cannot do outside of an open session of a properly noticed meeting. And this is something that even though this has been the law for, I think, 10 years now, we still have associations that don't understand that when the decision to turn a matter over to the attorney for a foreclosure action or an enforcement action must be made in the open session of a properly noticed meeting. And you have to do so really without using the owner's name or the owner's address. There's various ways to do that so that you can note in the meeting minutes that it was done without using a name or address. That's something you should definitely talk to your attorney about. And the reason for this being is that, let's say you file a collection lawsuit and you're a year into it and the owner gets an attorney and the attorney says, show me where the board approved this lawsuit against my client. And when that question is asked, the association should be able to produce meeting minutes and say, here it is, a year ago at our January 2023 meeting, this lawsuit was approved against your client. And as an example, a way to note that in the meeting minutes without using a name is that those January 2023 meeting minutes can say a motion was made to turn over every owner who has a balance of more than $1,000 to the attorney to pursue collection through foreclosure if necessary. And you produce that. You've got meeting minutes show that that motion was made, that it passed. You produce an account history from January 2023 showing that that owner had a balance of over $1,000. and you satisfied the requirement that the board approved this collection lawsuit in the open session of a properly noticed board meeting. Now, there is as indicated on the slide, there's an exception to that. If you are going to file a temporary restraining order lawsuit or a temporary injunction lawsuit, you don't have to have that turned over in the open session of a properly noticed meeting. So if you've got somebody that starts building something without approval that you need to stop, then you can file a TRO lawsuit immediately without going through a board meeting and the board approving that in the open session. So that's something to keep in mind. But really, every board member should be aware of the 15 topics that cannot be, the 15 items that can't be acted on by the board outside of a meeting. For everything that you do outside of a meeting, any decision you make, let's say replacing the pool pump at a cost of $1,000, at the next board meeting, the board should announce, these are the actions we took between meetings. And one of those would be the board approved replacing the pool pump. The cost was $1,000. A lot of times I see on agendas or in board meeting minutes that they'll say that the board ratification of decisions made between meetings. And that's not really technically accurate. To ratify something means to make it official. Those decisions between board meeting minutes are official when they're done. The law just requires that they be noted at the next meeting and put in the minutes. So it's not really a ratification. It's just saying we did this and it was official at the time we did it. So that's something to think about if you're using the word ratification on your agenda or in your board meeting minutes. Kyle, let's go to the next one. We'll talk a little bit about board meeting notice of board meetings. And again, the reference to Texas Property Code Chapter 209 means we're talking about non-condominium developments. Board meeting notice should include the date, time, and place and general subject, including a general description of executive session matters. Excuse me. And again, if you put in that language from the property code for the executive session, that is a general description of what will be discussed in executive session. So the language that I recommend that everyone use on an agenda is, if you know the board is going to consider and possibly vote on something, is to use the phrase, the board will consider and vote on X. For example, the board will consider and vote on approving the ABC landscaping contract. The board will consider and vote on turning deed restriction violations over to the association's attorney to pursue. For board meeting notices, if you're going to mail the notice, it has to be mailed at least 10, not more than 60 days before the board meeting. There's really very few, if any, associations that mail board meeting notice. Most of them now use one of the other two methods of notice, and that's just a 144-hour notice or a 6-day notice by putting it on the association's website and sending an email to everyone who's registered their email address, or by putting signs up in the common area and sending an email to everyone who has registered their email address. When you send that email should include the agenda for the meeting to give everybody notice of the general subject of what's going to be discussed in that meeting. So keep that in mind, is that when you send email notice of a board meeting, it should include the agenda, and the board can't consider a vote on anything that's not on that agenda. The argument being that an owner should be able to read the agenda, determine if there's something on there that makes them think, I want to be at that board meeting, I want to attend that board meeting, whether it's virtual or in person, to hear what the board has to say about this. Let's go to the next one, Kyle. All right, we'll talk about condominium meeting minutes now. If you see the reference to Chapter 82, that means we're talking about condominiums. Chapter 82 only requires meetings of the association once a year. Unless the declaration or the deed restrictions provide otherwise, special meetings of the association may be called by the president, by a majority of the board, or by unit owners having at least 20% of the votes in the association. Meetings of a condo association must be open to the unit owners. And again, the property code for condos, Chapter 82, gives the board the authority to go in executive session, and that really kind of tracks the same topics that's in non-condos, so that they have that same authority to go in and talk about these things. And again, if you're what the board wants to discuss in executive session doesn't fall under one of these topics, it's probably something that should not be discussed in executive session. Okay, the Chapter 82 for condos also allows the board to meet by any method of communication, including electronic and telephonic, if notice of the meeting is properly given. Each director may hear and be heard by every other director. And the meeting does not involve one of the following topics: voting on a fine, a damage assessment, appeal from a ACC denial, suspension of a right of a member before an opportunity to attend a board meeting to present the member's position. So if you're going to do any of those things, that has to be at a live in-person meeting. Property Code Chapter 82 gives condo boards the right to act by unanimous written consent, and that's a little different than non-condominiums. In non-condominiums, Chapter 209 of the Property Code allows the board to act just by a vote. So if a majority votes in favor of something, it's approved. For condominiums, the board has to act outside of a meeting by unanimous written consent. So that's kind of an important distinction between those two. And if the board does act by unanimous written consent, a record of the board action has to be filed with the minutes of the next board meeting. So something kind of quirky about condominiums is that there's no requirement like there is for non-condominiums to give the owners notice of a meeting. So you have to look at your bylaws and your declaration to see if there is a notice requirement to give owners notice of a board meeting, which is kind of odd. It just doesn't seem right, but that's what it is. So if there is no notice requirement, the board does have to give notice if they receive a request in writing from a unit owner asking the time and place of the next regular or special meeting of the board. So, and if whoever that letter sent to, a board member, and they don't know when it is, once they find out, they need to notify that owner of when that next board meeting is. So again, for condominiums, there's no requirement in state law that notice of board meetings be given to the owners, but there may be a notice requirement in your declaration or in the bylaws. So you need to make sure you're familiar with what those documents say about notice to the owners. Talk a little bit about amending the restrictions. Again, the reference to Chapter 209. So now we're talking about non-condominiums. So there's a statute now that allows 67% of the owners to amend the restrictions unless there's a lower percentage stated in the restrictions. So if you have a board that wants to amend the restrictions and you go and you look in your declaration and it says that it takes 75% of the owners to amend the declaration, this statute lowers that to 67%. If you go and look at your amendment language and it says it takes 51% of the owners to amend the declaration, then the 51% controls and not the 67%. Something that probably should be obvious to everyone: you cannot amend your bylaws to conflict with your deed restrictions. So the declaration or the deed restrictions are one of the primary controlling documents. It can only be amended by amending that document. You can't have a bylaw that conflicts directly with a deed restriction. If you're during the development period, you've got to get the developer to agree to any amendment to the declaration. And just note that a 67% requirement to amend the declaration does not apply to an amendment that affects a portion of the subdivision zoned for or containing a commercial structure, industrial structure, apartment complex, or condominium. Those are kind of rare circumstances. They're probably not going to apply to most non-condominium developments, which are primarily going to be 100% residential. So now we'll talk about condominium declaration after January 1st of 1994. That's controlled by section 82.067 of the property code. And the declaration may be amended only by a vote or agreement of unit owners that own at least 67% of the votes in the association. And kind of the difference here is that, or a larger percentage that the declaration specifies. So in condominiums, it doesn't lower the percentage like it does in non-condominiums. If your condominium declaration says 75%, then it's 75%. Don't really understand the difference, but that's the way it is. There can be a smaller number than 67% if all of the units are restricted to non-residential use. So that'd be like a commercial condominium development. And you've got to follow the notice requirements for amending the declaration and the notice requirements in section 82.067. So something to think about if you're amending your declaration, that an amendment may not create or increase special declarant rights, increase the number of units, change the boundaries of a unit, alter or destroy a unit or limited common element, change a unit's allocated interest, change the use restriction on the unit, unless that amendment is approved by 100% of the votes in the association. So really the takeaway here is that if you need to do an amendment, or the board's talking about an amendment that covers any of these areas, it's really something you should probably go talk with your attorney about, as there might be an exception, but that's something that really you should get legal counsel on if you can do that, or and even if you can, if you should. The section 82.067 of the property code does give condos the right to amend the declaration to bring an action to evict a tenant of a unit owner for the tenant's violation of the declaration or any other rules or bylaws of the association. It allows, you can amend the declaration to bring an action to evict a tenant of a unit owner who fails to pay the association for repairs to common elements that were caused by the owner's tenant. You can amend your declaration to collect rents from the tenant of a unit owner who's at least 60 days delinquent in the payment of any amount due to the association. So these are kind of special rights that you can amend a condo declaration to take action against tenants. You don't have those kind of rights in a non-condominium development. Let's go to the next one. Obviously, an amendment to the declaration, whether it's a condominium or a non-condominium development, a single family or townhome that's not a condominium, you need to file that with the county clerk in order for it to be effective. And again, this is kind of reiterating the point we've already made, is that a condominium declaration may not be amended except at a meeting of the unit owners at which the amendment is approved by the holders of at least 67% of the ownership interest in the condominium. So, condominiums can be tricky. I always talk with your attorney about any condominium when you're trying to amend any type of condominium document, whether it be the declaration or just a rule or the bylaws. With regard to fining in condominiums, the section 82.102A of 12 of the property code lays out the procedure of what you have to do to fine, and this is somewhat similar to the procedure in non-condominiums. You have to describe the violation and the amount of the fine of the damage. So you have to send the owner a notice that describes the violation, and really you've got to concentrate here when you're doing this on making sure that the owner can read the description and know exactly what you're talking about. From time to time, we see fine letters or even deed restriction violation letters sent by associations, and it's just not clear exactly what the violation is. And if we can't understand it, it's more than likely that the owner doesn't really understand what you're telling them either. So make sure that those descriptions of violations in any kind of letter you send are reasonable and clearly state what the violation is. Back to fining, the same as in non-condos. If you're going to levy a fine, you've got to give the owner 30 days to request a hearing before the board. You've got to give the owner a reasonable time to cure the violation and avoid the fine. And if the owner commits a violation, you send them the fine letter, and then they commit the same or similar violation 3 months later, you don't have to send them a notice again. You can just fine them. So let's see. Now we're going to talk a little bit back to non-condominiums, back to single family. So if a hearing before the board is required by the statute, which now there's a couple of different times when you have to give the owner the right to a hearing. You've got to give the notice. You've got to give written notice of whatever it is. If it's a violation of the deed restrictions that's curable, you've got to give the owner the notice that they have the right to ask for a hearing. And that letter also has to state that if you're going to pursue attorney fees, that notice has to be in that letter also. If you have to give the owner the right to ask for a hearing, you've got to deliver a packet to the owner containing the association's evidence that it will introduce at the hearing. So for example, you've got an owner that has a car parked in the yard, and you write them a violation letter. And in response to that violation letter, they ask for a hearing before the board to discuss it. At least 10 days prior to that hearing, you've got to send to them all the evidence you're going to talk about. So that'd be pictures of the violation, a copy of the deed restrictions, a copy of the violation letters you've sent them. So if you don't get that evidence to them, the owner is entitled to postpone that hearing. During that hearing, the board has to present its case, which basically would be, we wrote you a letter saying you've got a car parked in your yard. Here's a photograph of the photographs we have of that car parked in your yard. Here's a copy of the declaration showing that expressly states in this provision that you cannot park a car in your yard. You present that case, and then you let the owner present their rebuttal to that case. Keep in mind that you've got to give the owner at least 10 days notice of that hearing, of the date, time, and place of that hearing. The hearing has to be conducted within 30 days of receipt of the owner's request for a hearing, which that's a tricky one for a lot of boards. A lot of boards want to push it to their next board meeting, which may be longer than 30 days away. Which another thing to remember is that if the owner agrees to a different time frame, then that's fine. But if they don't agree to it, you've got to comply with the statute, which is fairly rigid in that time frame that happens. The statute also give either party the right to postpone the hearing for 10 days. Keep that in mind. It's really something that you want to try not to do that. You just want to, if they ask for a hearing, schedule it in the proper time frame, have the hearing, and move that matter forward. Something to keep in mind in non-condominiums is that there's two types of violations now. There's curable and uncurable. A curable violation is something that's ongoing that can be fixed. Owner hasn't painted their house. Ongoing noise violations, car parked in the yard. That's something they can fix. A non-curable violation is something that has happened, but it's not ongoing, like a fireworks or a one-time party where there was a lot of noise, a garage sale if your declaration prohibits garage sales. And kind of where this comes up a lot of times is in fining. Prior to the law change, you always had to give the owner, before you levied a fine, the right to cure the violation and avoid the fine. Well, there's no way to do that for something that's a one-off that's already happened. You can't give them that time to cure the violation because the violation happened and it's not ongoing. So that the law was changed to kind of separate out these two different types of violations. And if you're fining somebody, you've got to determine what type of violation it is, and that's going to affect the type of 209 fine letter that you send that owner. So again, before you levy a fine on an owner, they have to receive a 209 letter. It's just that if it's a curable violation, if it's an ongoing violation, you have to give them the opportunity to fix that violation before you levy the fine. If it's a one-off uncurable, You still have to send the 209 letter before you levy the fine, but you don't have to give them the opportunity to cure the violation. So that's something to keep in mind if you're going to fine someone, is determine what type of violation it is, and then that will affect the language in the 209 fine letter that you send them. All right, I think that's all we're going to talk about today. We are going to have, like I said, in the near future, a Property Code 201 webinar that's going to talk a little bit more about collections and foreclosures, the standard of care, attorney fees, and 202 provisions. So I know that we do have a lot of emails or a lot of questions through email. I'm going to try to answer those. Kyle, can you put those up on this? Let me see. Let me see if I can find them. Okay. First question I see is, can you use photos along with the letter describing covenant violations? Yes, that is always helpful. If you send a violation letter, to include a picture of it, and that way there should be no question as to what the association is talking about. The board does not mean the entirety of the board must be present. So this is probably talking about in the context of a hearing with an owner. You should at least try to have a majority of the board present at a 209 hearing. And again, you don't have to make a decision at a 209 hearing. You can present the association's case, let the owner talk, and then inform the owner that, okay, we have all the information we need. We're going to tell you, we'll inform you later in writing of what our decision is. If the hearing took place, but the board did not approve or disapprove, do we need to send 10-day notice again to the owner if the board reviews and votes at the next meeting? No, I think the question, what I just said, probably applies to that. You don't have to make a decision at the hearing. Obviously, you should try to make it within a reasonable time, as soon as possible after the hearing, and inform the owner in writing of what your decision is. Does the associate?
Before you go on to the next one, there's a lot of questions up before all of those. So I want to make sure we get those. If you want me to, I'll read them for you.
Okay, go ahead.
All right. So somebody asked to clarify, condominiums do not pay property tax?
Condominiums do not pay property tax. That's all really figured into the owner's ownership interests in the common elements and their unit.
All right. Next question. If condo owners want to demo their pool and do away with the asset, do all the members have to approve?
You know, that question is going to be specific to that condominium. That's something you'll need to talk with your attorney about, so that they can review the governing documents to see if they speak to that, or how they speak to that.
All right. So I think we were talking about fining at the beginning, or open records at the beginning. So what do you do? What do you do if there's not an open record policy for the association?
Well, first you adopt an open records policy. It's required by law, no matter what size the association is, to have an open records policy. I would still comply with the statute. So what, when you get that, like I said, when you get the open records request, a clock starts ticking, and that's all in the statute. Basically the open records policy that's filed just kind of reiterates what the statute says. But if you don't have one, you should get one filed as soon as possible.
All right.
And if you receive requests, comply with the statute.
All right. Next question. Does the record policy apply to developer communities?
Yes.
Okay. Can you keep electronics or keep records electronically, or do you in a database, or do you have to have hard copies?
No, you can keep them electronically, and hopefully that's where a lot of associations are going.
All right. Next question. Is the HOA required to have a filed records and retention policy, or can they fall back on the property code?
Do you have to have a filed open records policy?
All right. Next question. Is an email request through the association website considered an official request?
No, I think that the non-condo statute 209 requires that the records request be sent by certified mail, and I believe the condo statute has the same requirement. So if you receive an email request, the response will be, you need to make a if you're not a condominium, you need to make your records request in accordance with Chapter 209 of the Texas Property Code.
All right. Next question. Going back to the board communicating, what if the board does activity via text message, phone calls, or emails? Does the board need to maintain those records?
It's not a bad idea. There's always a question: are emails and text messages association records? I don't necessarily believe that they are, because the association doesn't maintain them. With regard to emails, something that, just kind of as a side note, that I recommend that all board members, for emails for association business, that you create a web-based account and not use your personal account to send association business emails. That way, if there's ever a dispute and there's a lawsuit and there's a discovery request for emails, you can point to your yahoo.com account that's only association business and say, have at it. If it's on your personal email, there is a potential that someone can get to your computer and search your computer for related emails. So you just want to avoid that. That's would be rare if that happened, but there is that possibility. It's better. The best practice is to just keep that business separate.
All right, now on to board meetings. Can you stop an open meeting at any time to go into executive session, or does it have to be scheduled?
The best advice is that it be scheduled, but I think that if you're in the middle of and something comes up, that you can stop the meeting, go into executive session, clear the room, talk about what you need to talk about, and then come out of it. But there should be an executive session on the agenda.
All right, next question. When there's a vote by the board and the board wants the individual names entered into the minutes on how the vote went, is this allowed?
It is allowed. It's not required. I have some associations that, put how every board member voted on everything, and then I have some that don't. But you can do that if that's what the board wants to do. But like I said, it's not legally required, but it is allowed.
All right. Next question. What verbiage would you put into the minutes summarizing the executive session?
Well, I think it depends on, what you discussed in the executive session. So that's really probably something you need to talk with your attorney about. But, a lot of times I say that the board, in executive session, the board had a contract negotiation with ABC Landscaping. The board discussed delinquent accounts. The board discussed current deed restriction violations. And you just have to generally describe that. And again, if a decision was made, you have to say what that decision was. But like I said before, I'm not sure what the types of decisions boards are making in executive session. And typically when I see a decision that was made in the executive session, it's something that should not have been done there.
All right. Next question. Can we use account numbers in the minutes for accounts escalated to the attorney?
Yes, and that's one of the methods you can use is, most management company softwares assign an account number to every property. So for example, if you're going to turn somebody over for a deed restriction violation, the motion that's made in the open session could be the board. I'm making a motion to turn account number 1234 over to the association's attorney to pursue a paint house violation. So then if a year from now, the attorney comes back for the owner and says, show me where this was approved, you show them those meeting minutes, you show them a management company report that ties that account number to those meeting minutes.
All right, next question again regarding collection actions. Is it acceptable for the board to adopt a policy with direction to the management company that, for example, every account that exceeds $1,000 balance be turned over to the attorney for collection, up to and including a foreclosure lawsuit? With this, is it then necessary for the board to vote per account in meetings, or does such a policy cover these actions ongoing as needed?
So we prepare a collection policy that has language similar to that basically gives the board or the manager the right to turn over an account for collection just by the adoption of that policy. We don't know what the answer to that is if somebody challenges that and says, well, they didn't do it at a board meeting like they were supposed to. even with those policies, the best advice is to always do it at a meeting. You know, if you're relying on that policy and you didn't do it at a meeting, what you're doing is you're giving an attorney something to argue. So the easiest way to avoid that is to do it at a meeting. And I recommend to my boards that on every month they have 3 agenda items, and this is assuming that they have fining authority, and that those 3 agenda items are: the board will consider and vote on turning over deed restriction violations to the association's attorney to pursue through lawsuit. The board will consider and vote on turning over delinquent owners to the attorney's office to collect through foreclosure if necessary. The board will consider and vote on levying fines against owners who are violating the deed restrictions. And I recommend that those be 3 standing agenda items every month, so that it's always there. If 2 days before the meeting, the board decides they need to escalate something, and then they're always there. And if you don't have something for that agenda item at that meeting, you just pass the agenda item. But again, we do recommend those collection policies, and that's primarily to try to cover the association in the event that they didn't do it properly in the open session.
All right, next question. We got about 10 minutes left, and I know a lot of you are asking a lot of good questions, so we're going to try to get to as many of them as possible. Can you elaborate on what constitutes as an enforcement action?
If you're going to pursue a violation of the deed restrictions.
All right, next question. Is it permitted to only post at the office or on the website? Many members do not use email.
Well, you have to post on the website and send an email blast to everybody who's registered. There's no requirement that they register, but if you only have 1 email that registered, you've got to send the email. You've got to send the notice to that email.
All right, next question. If an association wants to send accounts to legal prior to their next quarterly meeting, can they do this with a ratification at that next quarterly?
No. So that goes back to that the initiation of a foreclosure action has to be done in the open session of a property notice board meeting. If you've got a policy that we just discussed, you can rely on that policy, but again, that's going to leave an opening for an attorney to argue that it wasn't done properly. So, keep in mind that now with virtual technology, you can have a board meeting that's a 10-minute board meeting at, during business hours, just to vote on these types of things. And I've had a number of those where, somebody says, we need to turn collections over now. We don't want to wait till our next board meeting. So we schedule a board meeting either during the day or even early evening, call the meeting to order, establish a quorum. There's only one thing on the agenda, and that is, to turn delinquent owners over to the attorney. There's no homeowner forum, and that's a meeting that's less than 10 minutes.
All right, next question. Is the board required to supply the members with the most recent financials before an open meeting?
There's no legal requirement to do so. Now, I'm sure you've all heard owners argue over and over about transparency and communication. So all of those things you should try to do. You should try to make your financials transparent, put them on the website if it's behind a locked website that only owners can get to. The more information you give owners, the less they have to complain about.
All right, next question. Our company uses Town Square to post notices. Does this serve as a website?
I believe that it does. The only concern I may have is that if somebody's not registered to Town Square, I don't know the ins and outs of Town Square, is if they can go and see the notice if they go look for it, or if they have to be registered.
All right, next question. I think you pretty much already covered. So 2 to 3 residents who don't use internet, you can specifically send a letter or notice to those and email them to others, correct?
Yeah, you can give notice. So there's 3 ways to give notice of a board meeting: by mail, which is a 10-day requirement, posting on the website, and sending the email blasts. And the third way is putting up signs and sending the email blasts. We have some associations that use, 1 or more of those, so you can mix and match.
All right, we got the 5-minute warning just a second ago, so I'm going to try to get through as many of these as quickly as possible. Can the board send an email only for suing a homeowner?
So I assume you're talking about a violation. I mean, you can send an email, but at some point, the 209 letter needs to be sent. The 209 violation letter needs to be sent, and that needs to be sent by certified mail. And of course, our recommendation is anything that you send that owner by certified mail that you also mail at regular mail.
All right. Are board meetings appropriate places to hear members' complaints / issues?
Yes. So, I generally recommend that every owner who attends a board meeting should be given the opportunity to speak if they want to. That would come during the homeowner open forum, whatever you call it, that typically is at the end of the meeting. You may have to set a reasonable time limit on it, because I'm sure you all have owners who would get up and talk for an hour if they can, if you would let them. But, if someone shows up to a board meeting, my recommendation is you give them the chance to voice their comment or concern, whatever it may be.
All right. Can a board amend bylaws without the members voting? And there's a follow-up to this. Can the amendment be done using the business code?
We believe that it can. So the Texas Business Organizations Code allows for the board to amend bylaws. There's 3 exceptions there. And if we have an association that wants to amend their bylaws and the bylaws don't expressly state that the board can amend, we take a look at what the bylaws do say, and then we take a look at the Business Organizations Code to see if any of the 3 exceptions apply. And if they don't, we believe that the state law trumps what's in the bylaws.
All right. I'm just going through and trying to get through as many easy ones as possible. The recording will be posted to our website and on our YouTube page. The copies of the presentation will be sent out via email to everybody that's attended. So those will be sent out. Our POA is subject to property tax on common areas.
Yes, but it's usually a nominal value. So like in Harris County, common areas are usually appraised at $100. So the tax is nothing. Hey, Kyle, I see one here that I want to speak to. Talking about an open records request. Can a person request to see the completed ballot of another individual on how they voted for a board member at an annual meeting? If you're in a non-condominium association, so this would be a typical single-family home, the only people that are entitled to see ballots are the vote tabulators or a person that performs a recount. The property code provides a procedure in which an owner can request a recount, has a list of the people that can do the recount. So those are the only people that should see ballots. Vote tabulators, which is typically going to include a management company representative or 2. But no, if you're in a non-condominium, an owner cannot make an open records request to see a ballot. Kyle, you got another one you see there?
Yeah, I'm trying to find. So, can a person request a copy of official community email sent before they purchased a unit in a condominium?
Well, they can ask, but you don't have to give them to them. I mean, the open records only applies to owners. Can you show the owners the tabulation sheet? I don't really have an issue with that, of showing. I generally believe that in an election that you should announce the name of every candidate and how many votes they received. Some boards don't like to do that. It might be embarrassing to some of the candidates, but to me that just goes to transparency. This is in every other election, how many votes everyone got, and I don't know that it should be different in association elections, just for transparency's sake.
All right. Here's an interesting one, Cliff, and I think it's a caution for others. How do you cure a situation where, one, you took executive session minutes and then they were accidentally distributed to non-board members?
Well, first off, there should not be executive session meeting minutes. There should be one set of meeting minutes, and that's the meeting minutes that are kept for the meeting, and everybody can see those. If you take executive session meeting minutes, those are records of an association, and there's no protection for those. I'm not sure what you would put in executive session meeting minutes, but we recommend against keeping 2 sets of meeting minutes.
All right, we'll do 2 more quick ones real fast, and then we are out of time. So is there a deadline for the board to give the decision from the hearing?
There's no stated deadline, but again, it should be as soon as possible. I mean, most of the time after the hearing, the board knows how it's going to go, what the vote's going to be. I would try to get it out within the next week in writing to the owner, but there's
All right.
nothing stated in the law about it.
All right, last quick one. Can you confirm if an appeal to the ACC denial be addressed via Zoom?
So one of the things on the list of the 15 items that have to be done in the open session of a properly noticed board meeting is the appeal of an ACC denial. And that's another one that surprises a lot of boards, because you would think that's something, and it seems logical that that's something that's not done in front of all the other owners. But keep in mind, that's what the property code says. The denial of an ACC appeal should be done in the open session of a property notice meeting unless the owner agrees to do it outside of the open session of the meeting. And that can be held by Zoom if you're having the meeting by Zoom.
All right, Cliff, I think we're about out of time. There's a lot of questions on here for board meeting stuff. I think we'll try to get a board meeting session scheduled on the calendar to where everybody can come back and we can talk exclusively about board meetings and things that need to go on. So watch your email for those. This is the legislative session year. Come March, we are going to start monthly legislative updates via Teams. So be on the lookout for those as well. And if there's anything you guys want to see, let us know. Type it in the chat here. You can email me at kbeam@rmwbh.com. We'll start building some sessions for you guys.
And Kyle, I think a board meeting one there's always a lot of questions about board meetings. So we need to develop that one and get one out there.
Yes, sir.
All right. Thank you, everybody, for coming.
All right. Thank you all. Have a good day.